What's going on, everybody? TRAE4PAY back in the building, coming at you guys with day one of the Darrell Brooks trial. Now, I did put up in a community post that I'm going to be reacting to the trial in its entirety just because I keep getting confused with those parts that I'm uploading just because I don't understand why they're doing certain stuff. Before I begin, I gotta say, if you enjoyed the video, please like, share, subscribe, do all that good stuff, man. I don't have too much to say. This is going to be a pretty long video. Probably going to do half of this day and then I'll upload the last half tomorrow. But yeah, without further ado, let's get into it.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
And would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now,
his sovereign citizenness.
Reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning. Mr. Brooks, it wasn't the proper
you could have waited
time
till
to
she
do that. That's now the third interruption.
finished.
So,
To state what you need to state.
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done. I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of...
This is why I said he has some kind of weird idea as to how this trial thing is supposed to work. Like, I think he just thinks everything is supposed to be fair, so it's fair for me to, like, just cut you off. When you're saying something, it should be fair for me. When it's like, that's not at all how this works, okay? Even I know that, like, with my limited amount of knowledge about the court system and how that all goes, even I understand, look, the judge is at the top of the totem pole in this situation. You have to pretty much listen to what she's telling you to do, okay? So if she says stop talking, I think it'd be in your best interest to stop talking, especially since your freedom is in the is at stake here. Like, why would you even do that?
The
pretty dumb
Supreme Court rule. It's on a yellow
stupid
laminated
move, but it's Darrell.
double-sided. I checked, I verified, it is. Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I give you an opportunity. No one else is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently...
So wait a second, there was a day even before this? Yo, I had the idea that, like, this was the very first... Well, not interact, because I did see something. Like, I saw him sitting beside a couple of attorneys or something like that. and he had like some dreads and all this, but like I assume this took place right after that. Okay, so
Effectively
apparently
and with
this ain't
dignity,
the first time they've had to
preside
deal
over
with
this
him.
case here today. I
I
am
object-
well
I
aware,
object
that's another
respectfully, Your Honor.
interruption. I'm
I-
well
I
aware,
object
stop
respectfully, which I have
talking.
the right to do.
I'm well
And
aware, Mr. Brooks, that
No,
you
you
object to the
don't.
name that
Cause any,
has
disruption.
identified on the information and all documents in
want it
this
noted
case.
for the record
Your
that I do
objection is
not
noted, it
identify
does
by
not
that
need to
name.
be repeated. I will make a record right now. The court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection by Mr. Brooks of his name.
And this shows that this was
and,
planned,
that
bro.
he objects to being here.
It shows that this was
I
the
know
plan
he's filed
from.
a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent to being
participate.
removed from
Please
the
do.
courtroom.
Please.
That's another
And you
interruption.
haven't shown me any lawful, case law that I can be removed from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress to appear in a trial that I am needed, that I'm trying to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have,
Well, this is why you shouldn't have represented yourself. Like, okay, once again, I barely understand like the legal jargon of it, but like, so now it sounds like he's saying I need to be shown some kind of paperwork to say that you can have me escorted to the other courtroom. It's like, bro, this is, once again, you chose to represent yourself. Okay, so the fact that you don't understand why they're doing certain things or what it is that they're doing, why she's able to make this happen or that happen, that's literally all your fault. You know? Because he chose this path at the end of the day.
have not followed
He's the reason why
that proper
they-
procedure. You are unable or
They're not here to
unwilling
show you why
to
it's
abide
happening or
by
what
simple rules of civility.
can
You
happen.
interrupt,
Chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom.
Please do.
So you are
Object to that,
once
Your
again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled, okay? There are skirts
My
around
feet are
each
shackled.
one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, their arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know
That's
that
what
I'm
she
in
said
custody?
to you.
Mr.
Who
Brooks,
doesn't know that?
I've had many trials with individuals who are in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back
It just looks
to your
better.
cell
You know, if he
and be
would have wear a
dressed
suit
in
instead
the
of that,
street clothes that you previously appeared in?
just looks
With all
better at
due
the end of the
respect,
day.
I do
She's
not
helping
agree
him
with
out.
that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media.
And once again, I don't know who this bailiff is. He wants to choke him out too. Everybody wants to get their hands on
Shown
this
every
thing.
day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
Of course not.
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street
I
clothes?
do not consent
To being
or
called that
agree
name.
to anything that you just stated.
Oh, okay. Well, at least he said
And
something
he
different.
did not
He mixed it up a
provide
little
an
bit.
answer to a very direct question. Let the record be very clear that
So
Mr.
much
Brooks
patience,
was given
bro, from this
multiple
judge.
opportunities to answer that question.
I
And go
answered
back,
it.
Mr. Brooks, that's yet another interruption. I will advise you,
Right,
sir,
he should be
that
glad I'm not
at
his
any point
judge.
in time,
After
if you
that
wish
initial
to
question,
put street
if
clothes
I did
on,
him a solid like that and I asked him, you know, hey, maybe you should go put some street clothes on, man. You know, it'll just look better. You know, to the jury, make you look a little bit better, more presentable. And then he gives me like that BS response. Man, we move on so quick. I wouldn't even
I would give you that
repeat it
opportunity to
again.
do so. You've already
Okay,
heard it
there you
is my
go.
preference.
That's your answer. Cool.
You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about
Did not
whether you
refuse.
would
I answered it,
go
you just
back
didn't
to the
like to
jail.
answer
That's
it.
another interruption. So based on his refusal and his
I did
choice
not
to come,
refuse.
that's
I did
another
not consent
interruption.
to saying
Based upon his
refusal. I answered.
failure to answer my question directly, I will
I
take
did
that
not
as
refuse.
a non-response, but he came to court
That was
here
not a
today. That's another
non-response, Your Honor.
interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily, and intelligently. No one has forced him to come
I
to
did not
jail in
consent to
those
that.
clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you
of
may
the
not,
court?
sir. You need to file a motion in order to do
Oh, the
that.
first subject matter jurisdiction of the
So,
video.
Mr.
the
Brooks?
motions I filed haven't
First
been,
one.
Responded to. I gave.
Mr. Brooks, you're
3 days.
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
Thank you.
courtroom.
consent to that.
I have
I'm
had
under
a
duress.
dozen
He's so happy to
more
get up and get moving.
interruptions.
I
We'll
have
be
shock-
off the record while
shocks
we do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I not consent or agree to.
I don't agree to a stopple.
I have a right to be present for trial.
Man, get out, go to the other courtroom.
You're able to see the screen, is that right?
Okay, so they got him to the other courtroom now, I think. Let me see.
All right, we are back on the record. Appearances are as they were before. I need to
Yo.
make the record that at 8:42 a.m. this
Yo, look at this clown, bro. Look at this. Hey, this is the man that was surprised, y'all, that he got
court ordered
he
Mr.
got
Brooks
guilty
be
on all
removed from the
charges.
courtroom due to repeated interruptions and
Hey,
disruptions.
he was asking for it.
With the
He was
court.
asking to be found
This,
guilty
of
and everything, and
course,
I'm so happy.
Comes on the
Look at this
recent
grown man
history
right
with
here, y'all.
Mr. Brooks on every day that we have been in court since Monday. He has shown a complete and utter disrespect.
This is
for the
like straight
simple
up middle
rules of
school.
civility.
Like I seen middle schoolers act just like this,
He
to
has
take
been
their shirt
removed
off
from
and
the
stuff, and they
courtroom multiple
refusing to
times.
move and everything
This
you tell them
morning
to move.
alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off
Hopefully
a
some
shoe,
extra charges on
and it
him.
appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual.
I can hear him and I don't even hear him. Like it's like just based on the way he's moving, I can hear in my head how he probably sounds.
There is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either.
Because you have a lot of patience.
The third is to take him out
really
of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this
I mean, she did the right thing.
continue.
She did what she had to
Again,
do.
Mr. Brooks
Like,
is given the opportunity to appear from that other courtroom.
because he already showed no matter
At
how
this
much leeway
point,
you
I'm
give him,
still in the
he's going to just do what
final
he wants.
housekeeping
You know?
matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks,
hold on,
as
I'm
I
sorry.
have advised him repeatedly,
Trying
at
to give
any
her a
point
chance
in
to talk
time
and
he
not
wants to
be
come
like
back,
Darrell Brooks.
and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings, for all individuals in this courtroom, including Mr. Brooks himself. Then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the
I know he was trying to say they did something to his arm.
preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to
That's
delay,
right.
to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear, if appropriate.
She's giving them warnings too. She's telling them straight up, dude, just conduct yourself this way. It'll be easier for you.
We need to
It'll make you look
reset
better.
the Polycom system,
But
so I'm not sure what that means. I'll
Doing
find
what
out,
he
and
does,
if
man.
appropriate,
Whatever he wants to do.
make a record as to why and whether that impacted anything that was happening in the other room. But at this point, while I'm not going to get off the bench, we're going to take a short recess for that resetting to take place.
I would request an opportunity then, Your Honor, when we go back on the record, please.
Absolutely. System has been reset. The information I received was that all of a sudden the audio was only going through 2 speakers and not all of them. A simple reboot of the Polycom system over there took care of that, and I have confirmed that it's working properly.
So he can't say he don't hear
Before
him.
I turn to you, Attorney Opper, because I'm not sure if
I'm glad she's
Mr.
being
Brooks
thorough.
heard
What
this
is he
or not.
doing,
At
bro?
the very end, before I removed him, I wanted to make sure that the record is very clear.
But this judge is very thorough. Like, she's eliminating any possibilities. Anything that he can say later on to, like, wiggle out of
will note a
the crazy
continuing
stuff he did.
objection to the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself if it had a concern as to the competency of any defendant to proceed, can request an evaluation. That's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to he is coherent, he is intelligent, he knows the issues in the courtroom, he discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to...
I will say this, I do think something is like not right with him up here. Like with all this being said, something is off.
Today's filing, which Mr. Brooks provided,
especially for him to just do the stuff he did, like it's something
written.
Not right.
His handwriting is immaculate, it's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case, so he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court, most of them
bailiffs in there
to his detriment.
Got to babysit this dude.
His behavior became more and more.
You can tell they coming in there like he probably, so apparently him doing all this and stuff, like when he was holding up his pinky, I guess he was fussing about some hand sanitizer. I don't really know. But you see it, and then they brought it in there for him. And I guess he's fussing about something completely different now. So now they got to go back, put the sanitizer back. He's just doing whatever he does. Whatever room he steps in, he's just trying to disrupt the flow. Because that's like his thing, apparently.
It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had
Bro just brings chaos.
Then we had
wherever he steps.
Situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable.
You feel the walls closing in.
And I want to make that record. I tell this court, as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed, and we have had many, many dealings with him on the record and off the record that I base that on. I also
Man,
wanted
it's-
to add one other comment as to the court's record.
She put
As
that
to the need to
amazingly.
proceed with this
Like,
trial, we concur 100%. We would also note it's not just a matter of resources.
nobody's leaving him
It's
room to
the
wiggle out. I
need
love
to
it so
proceed
much.
to justice.
I love
It's
it,
the
dude.
need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty, that doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that
100%
with
right.
the court, because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements
It's going
as an
bad for
officer
Darrell.
of the court. I look forward to further reviewing them if need be.
The judge
changing
completely
any,
agrees
conclusions
with the
that I've reached
prosecution.
here today, and I would require you to file
We all
that,
agree with them. So it's not
exhibit,
going well.
so that
Day one
that can be part
of
of the
trial.
record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted.
So yeah, excuse me. It's something off with him, but I guess like in that area, they're saying like at least he's fit to stand trial. Like, but when I say something's off with him, I just think like in terms of his value of other humans around him. Like I feel like when he doesn't get what he wants, it's just destruction. Like destruction mode is unleashed, as you saw what happened. Like something happened between him and his ex-girlfriend, I think, and that just put him in pure destruction mode where he just went and did the terrible stuff that he did. So I just mean in that way, something's clearly not right with him in the head.
Well.
If you look at other people and feel that way, and like
more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue.
Because a lot of you in the comment section say he suffers probably from some kind of narcissistic
has the right to a speedy disposition.
Personality disorder. I don't know if that's how you say it, but dude's a narcissist pretty much.
And
when he doesn't get what he wants, it's just destruction mode.
System to go forward with this proceeding.
And unfortunately, I know a lot of dudes like that.
With Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things. Frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so.
My friend used to pay $163 for car insurance. Now look how much he pays.
So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced
He's gonna say he
yesterday
never
that
got
also
it.
have the rules of evidence.
He's gonna say you never gave that to me. I
and-
never got a chance to read it.
So
Well,
I wanted
okay.
to make that record.
Attorney.
I don't have anything from him
I
this
wish you would
morning,
get smart with and say, okay, attorney.
regarding
Yeah.
any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have,
Any objection to those?
no.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday.
I just
and
wanna know about
specifically
subject matter
looking for a
jurisdiction.
yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, no need to turn him off. It's not very well. I don't know. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Where is the microphone?
Oh my
It's in
goodness.
front of the monitor.
We already know what's about to come out of this once they they get his volume up. A headphone user warning. I'm gonna just go ahead and
Mr.
say
Brooks?
it, so I don't have to edit it in.
Try again.
Am I on the record?
You are on the record. Oop, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer please. All right, your objection is noted for the record, and
I think he
I'm
said
just
I
going to mute
object.
that on. You provided that objection without any legal
Right, he's so
basis.
mad he can't go further.
Um,
Oh my goodness.
I muted him just so I could ask this question. I'll be right with
He
you,
mad he
Kristen.
can't go on his
Mr. Brooks, do you have a legal basis to object to those preliminary?
he
jury
can't go
instructions?
further than that.
I'm
He's so
muting you.
mad, bro.
Hold on, it's the volume is not being appropriate at the moment. Then- Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer. So
Every
it's
time
kind
he
of that
feel,
record.
yeah, like he defeated. Like I can't
We
believe
will
this.
take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there. Here to have our technical issue resolved. That issue solely concerned the audio from the microphones in front of Mr. Brooks and the two room systems cooperating, and we were having difficulty in this courtroom hearing Mr. Brooks. I believe that issue has now been resolved. When I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting
can't
a
even
small
take him
cut
serious,
to a
though.
finger as a result of when
Look
he
how
was
calm he
removed
be. He
from
look
this
like a
courtroom
defeated
and
little
taken to
kid.
the
Oh no,
other
he's
courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done. And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I
The
want you to be
tactics ain't
advised
working.
that I believe it's
And he's
important
seeing it.
that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle as you are in custody, and that is
Yes.
appropriate. Now, I want to turn back to the issue with the jury and
Cause he ain't got the sense to act like an adult. You gotta force this dude to conduct himself like an adult, bro. Ain't that the craziest thing? And I'm happy. I'm happy that she's like, no, we gonna take a break and then we gonna force you to sit right.
instructions, Mr.
We gonna
Brooks.
force you to act
You
right.
indicated you had an objection.
We gonna do what you should have been taught as a kid. We correcting all
for
that.
the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to
Oh,
turn
he's
around.
so defeated. He said something. I don't even know what he
Mr.
said.
Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions?
I'm sorry I'm
I'll ask
laughing
the
so
third and
much,
final
y'all.
time, sir, what is
It's
the
just
legal
crazy
basis
to
for
see
your
this, though.
objection to the jury instructions?
I can't even hear what she's saying all the way. Too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on. I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those. Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper, and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in. I'm
Feel
not sure,
bad for
but
the
it certainly
bailiffs.
will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
Right. Thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opera, I have read.
Isn't it so much more peaceful, y'all? Like, even though just looking at him, because like I said, dude's energy radiates through the screen. Like, he has a pushy, rushy kind of energy, like, I'm trying to force you to do this and that, you won't do it, and so he's getting more aggressive. But like, this is much better. I'm gonna be honest. I'm happy I can't hear him and he's not in there messing up this.
Only one other observation, Your Honor, that since I filed that the events of the last couple days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify, and so not having their faces displayed.
That's right too, bro. Like, he put these families through so much, and then you got the nerve to be in the courtroom at like we're inconveniencing you by catching you and then holding you accountable for it. It's like, really?
I think
they back there and they.
Some of that
I'm not even gonna go into detail on that, but they dealing with a lot more than you
Brooks,
are.
my first
Okay.
question to you is,
we ain't even gonna play that game like
you have a position on the state's request in their motion for reconsideration.
Anything he's dealing with at this point, it don't even matter.
I'll unmute and provide
That's
that
coming to you.
Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written
Okay.
document that
Attorney?
was filed, and you were provided a
Your
copy
fault.
of that yesterday. We took a recess yesterday. Denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify.
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take your
It's a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google. And
Wow, look at him giving a little logical explanation to his point here.
and all these
Look at
different
that.
things, we got all this technology basically at our fingertips. So I don't understand.
I'm surprised, man.
How
I'm very
it needs
surprised.
to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be?
Okay, All right, we
and
got you.
because of the fact that you've already ruled on it, made that on the record.
Okay, you can mute him now. He's just talking in circles. He happy that he got a little
Just keep it the
audience.
way it is.
You can
Thank
mute him.
Mr. Brooks, I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for reconsideration.
That's not me.
Essentially, it requires that the
That's whoever
party
recorded
bringing
this.
the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 U.S. 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast.
Right.
Not just locally, but nationally, and frankly, anywhere in the world anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't frankly want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law. Certainly aware of the provisions that the state cites, but the fact remains the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how the
That's true. That's something I didn't even consider. Um, like there are so many victims in this situation. Like I can't even remember. I know he killed 6 people, but I think it's like 70 something. Um, it's like 70 people or something, right? That he injured, like with the SUV. So I'm sure their families would like to attend, or some of them would like to attend. But it's just crazy to think all the damage this dude caused.
This court has allowed the proceedings to be live
Like it just
streamed,
goes
that
on
we
and on. It's
don't
further
have
than you can
even a
even
full
comprehend.
courtroom
Like
here
how so many
today.
people he's
There
hurt
is
doing
no
this.
doubt this case has received great public interest. But this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be
Oh, it's
stressful,
gonna be
but it's
Darrell
important to
Brooks
the
is involved,
integrity
so.
of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course,
That's
when
understandable.
if and when a juvenile witness
And he hurt a lot of
testifies,
kids too,
may
bro. This is some
only be
sick.
captured
Yo,
from,
don't get me started on
these
that.
shoulders.
He hurt a
down.
lot
Their
of kids,
faces are
though.
not to be broadcast.
Jeez.
Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
But I did not hear if you, I was
He's still unmuted.
kind
I
of
didn't even know.
overhearing that you addressed the filing that I filed this morning. I
I did.
didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's
Still trying to
disclosure
slow it
statement by
down.
affidavit.
I bet
It's
you
an
he heard all of it.
affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted, it has been filed, and that your objection is noted. The court need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep
I
going.
was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so I
that
will-
for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
He back on this.
I had one other thing. Oh, I
Go
did
ahead,
wanna
mute
put
him,
on the record,
because he gonna keep it going.
And that is, when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
That is not accurate, Your Honor.
Mr. Brooks?
The reason,
Mr. Brooks?
I would just want it.
Hold on, I'm gonna
for the
mute you
record.
for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm
wanted
not
to go
asking
the
for a
record because
response,
it's
sir.
not-
Mr. Brooks?
It's not. It's
Okay,
not
you're
accurate, Your Honor.
interrupting, hold on.
Boy, this is court. This is not a conversation. He seems to think he just having a conversation with the judge instead of her determining whether or not he spends the rest of his life in prison. This
You're
ain't a
interrupting me,
conversation,
sir. I
man.
wasn't looking for
Okay.
a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me, and then I was told, no, she's going to come at the next recess, which we just took it. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
I didn't ask for a break. I was just saying that at the time that there was.
Sorry, my eyes are watering bad, Joe.
Before you even called that, Your Honor, I was told that a nurse was coming in at that time, but then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm gonna mute you for the time being. I want you to be aware, sir, I was advised regarding the cut, the bruise is new information.
Another
made a
delay tactic nipped in the
determination
bud. Let's
that
go.
You would be seen at the next appropriate
Boy, you've
break.
been denied.
From my perspective, a small cut and a
Denied, bro.
bruise is not going to hold up the
Oh
start
my
of
goodness.
bringing the jurors in
Stop
and
the
advising
court.
them of the
Stop the trial
preliminary
for a
jury
bruise.
instructions. If that means the next break we take is for lunch, and that's when you are seen, then that's what will happen. So, I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but you want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to.
Mute him.
Just like I should be awarded the right to be present for every
Let me
proceeding
make sure
in
I'm
this trial.
recording the screen.
Alright,
Yep.
I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
I think Mr. Brooks needs his objection signed.
We'll make sure he has it.
Thank you.
I'm going to read through the preliminary instructions at this time. Please pay careful attention. Just as a reminder, they're not something you need to memorize. Ultimately, at the close of the case, a very similar set of instructions are provided to the jurors to take back to the jury room. Before this trial begins, there are
Look how
certain
kind and
instructions
inviting
you
she's
should
being to
have
the jury,
better
bro.
understand your functions as
And
a
then
juror
you got
and how you
Darrell
should
out there
conduct
taking
yourself
full
during
advantage
trial.
of that. Like,
Your duty is to decide the case based only on the
Dude
evidence
is an
presented at
opportunist.
trial and the law given to you by the court.
I'm gonna skip over this part, y'all. She's just reading like rules for the jury and stuff. Yo, I'm trying to skip through, so I'm skipping through like her just reading through the rules basically to the jury. And look at this little piece of paper he's holding up.
Intent should
And how
not be
animated
confused
he's
with
being and
motive.
all this.
While proof of intent is necessary to a conviction,
Man, this dude knows how to make everything look aggressive. Like,
it's 1:22. The record to reflect that Mr. Brooks is back in the courtroom. I do want to make a further record that he still remains in his jail attire. Prior to the break, I did advise the captain and to let Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes. So it's his choice. He's here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you, I appreciate that clarification. Nonetheless, I provided you with that opportunity and here you are. Please be mindful, sir, that the right to be here can of course be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would of course be subject to removal and forfeiting your right to be present in this courtroom.
I'm so used to hearing them say subject matters jurisdiction. I
All
almost
right,
thought
is
she
there-
was gonna say it.
I'd like to bring
Like,
the
what?
jury out, Mr. Brooks.
She actually said it.
I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Talking about objections to strictly jury instructions or the filings that I filed on the 3rd.
I'm not addressing those at this point, sir.
I was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about
Attorney.
objections during this court
Okay, attorney.
hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but.
It's amazing that she's actually helping them too
and
with
I'm not
stuff.
gonna
Like
repeat myself. So, the record speaks for itself. Your objections in those filings to the.
like it still shows how patient and how much kindness she has, because she doesn't have to tell him this stuff. And for some reason he really thinks that she's supposed to, which baffles me, but yeah, it's cool that she even is taking the time to break this down for him. And it's helping him out.
Available for you at a later point in time, should you be convicted and on appeal, to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
The reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point,
He
there's
got
no
another
evidence
question
being
locked
taken.
and loaded. Look at this.
We're not at that stage of the proceedings.
Some like surface level.
So you will have an opportunity
Could you just
after the
explain
state
this
presents
to
their
me?
case in chief, and they rest, to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not gonna go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure.
Right.
But I expect you to not bring that up at this point in time or going forward.
And though, Your Honor,
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions.
I want to see if he's gonna hold it together when the jury comes out. Because this
just
whole,
for
I can't even.
reference for everyone, I've read through.
I can't remember if the
44
jury was
pages
out in those
of
other
69.
reactions I did. Like
And so I still have a ways
I feel
to
like that
go.
might have been, but I'm not sure.
My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof, and then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over here, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
Trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not gonna deal with it. If you wanna go to that courtroom, are you waiving your right to be present right now?
You chose to represent yourself,
Can I
sir.
at least raise the issue of subject matter jurisdiction?
He
That's
want
No,
to
there's
learn
no
on the
lawful
spot
motion
how to
before the court.
represent
You may not.
himself. Like,
the
and he acting like that's not right.
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you
Bro, that's like working for like NASA or something, right? Or that's like, yeah, they put you in a rocket ship and then they fire that thing off and then you up there like, okay, now what do I do? Bro, it's too late.
you have the
You're up there.
intellect to make cogent, coherent,
You either make it work or you
articulate,
don't.
responsive arguments when you so
This is not the
choose.
time to
But when
learn
you
how
start
to do
doing
what you need to
you're
do.
starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor. I
Your
respectfully
objection to my characterization of that is noted.
I would like to make a motion for finding the fact in.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to.
It's disgusting, man. In all honesty, like,
Of waiver of right to attorney. We went through all of the advantages, the disadvantages.
that he
We
did what he
advised
did and
of
he's trying
things,
to
including,
turn this like as
the
messy as he
charges that you
can.
face, the penalties that go along
Even with
with
what he
them.
did,
We
it shows
discussed
no
the
remorse, to be
difficulty
honest.
of representing yourself.
'Cause he's still playing
You
around.
made a deliberate choice to waive your right to an attorney, which this court honored and granted. And you, Mr. Brooks, don't interrupt me, okay? Now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It's not my
Mr.
intent.
Brooks,
It's not my
please
intent.
I'm not gonna force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at
He knows
your
what he's
peril,
doing.
run the risk of me admonishing you in front of them at this
Like
point.
all this fake
I don't wanna
confusion
do that,
and
sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you.
okay, if she's explained this amount of times or this many times that she cannot explain this to you, I think you would kind of take the hint as, okay, so I'm stuck in the situation I'm in, and you would be quiet. But he knows exactly what he's doing. Like, even though he's like, we all see what he's doing, in a way he's making it work, because he's like delaying it even right now as we speak. Like, all she's trying to do is just get the jury in there. And look at what he's doing. You know, he's trying to talk her in circles, keep her on the same subject, keep her talking around this, and like,
the understanding that you want,
I'm
all
not
right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking really to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present, because you're showing through your conduct that you will not follow the most simplest rule
Subject
of
matter
civility in a
jurisdiction.
courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment is not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So
I
at this
respect-
point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand. I'm
sir.
not. I was
If
in
you
the middle
have
of
an
saying
objection, write it down.
this is where it starts to get like
Apply to
super
me
difficult
being-
now.
It's
from
applying right
another-
now since you keep
I-
interrupting me while
So
I'm talking.
so what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you,
But she's told him numerous times there's a time and place to do this stuff, right? If you have she said if there was anything you wanted to take up with her, write it on a piece of paper, hand it to the bailiff, and you know she'll take it up outside of the trial, pretty much. And he understood. He sat there and listened to it, and now he's back to playing dumb,
keep trying to raise every time we're
trying to
in
talk her
here
in circles as much as he
are
can.
not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
And it's getting like more
Right?
difficult
I've
to really
already-
listen to this
I'm
because it's
not
like,
giving you advice. I'm not explaining
All
the
right,
law.
man.
I don't need to do any of that, sir. All right? You filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's
but
inaccurate.
I have addressed them.
That's
All right?
inaccurate, Your Honor.
Some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case. Madam Clerk, have the jurors brought in, please.
What you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor.
You can't have it both
will not
ways.
answer
He's trying to play
clear
the
questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive,
let me cut that off. Well, he's trying to have it both ways. Like, he's trying to play the I'm the defendant and also I'm the attorney at the, like, it seems like he's trying to be the attorney whenever he wants to, that's representing himself, and he's trying to play the I don't know what's going on. I'm just the guy over here that's, you guys are ganging up on me. I don't know what's going on. Like, look, you can't have it both ways. You agreed to be to have your rights waived, to have an attorney, and that's really it. Now you stuck out in the middle of the ocean pretty much.
respectful.
Figure out what to do. We can't help
if I
you
don't
out.
understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That
Oh my
should have
God.
let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification.
So he tried to change
I don't
words around to
understand
leave some wiggle room for him to
what is
pull
going
some
on.
crap later on down the road. You
It's
see?
not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
You give a dude like this an
understand
inch,
when
they
I
take a
tell you
mile.
not
He's trying to
interrupt me?
turn
Do you
all.
under-
understand when I tell you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I hope I use that right.
I still would
Give
like
an
to
inch
ask
and take a
questions.
mile. That's my
Stop
first time saying
talking.
that.
We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect, I
Mr.
still-
Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown.
is in the
I
courtroom.
understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor.
Man, if I had a son, okay, take what he did out of the equation. But if I had a son, just in general, that carried himself in this manner, right? I lose my mind. Like, if I saw my son somewhere, especially like in a school setting, like, I'll take that kind of example, in a school setting, and then you see him behave like this. Like, imagine how his parents must feel. Because I heard later on down the road, his mom is involved in this or something. Like, they bring her in. I think she comes in as a witness. I'm not sure. But, yo, it's got to be humiliating. Like, you see your son talking to people like this. Excuse me. He's showing no respect to this person. That, like, I would just be like, man, this was a fail right here on my part.
It's my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my
stand.
right.
You need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks,
This was
please
a
stop. I'm
fail.
going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I would do like he does. I don't
Mr.
know who
Brooks,
Darrell Brooks
final
is. That's my
warning.
son. I don't know who. I don't consent to him being called my son.
It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, can I?
Pieces of paper that Mr. Brooks wrote on. I'm gonna have them copied so the state can be aware of that and respond if necessary. So we'll just take a moment while those papers are copied. Call again. I'm gonna copy you now. We'll make sure you have copies of the filings as well, so you know what will be discussed, or at least addressed in some fashion. But I need to provide copies to the state. Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen, in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now. I know for a fact that's her. I don't want that to end up being an issue.
She
Is there
flipped
some
them
type
off.
of way that could be addressed by Your Honor?
How you expect me to feel,
Mr.
man?
Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Oh my God, that is
You
hilarious.
remember that I was not present in the courtroom. I couldn't see.
Yo, that is so funny,
All I
bro.
can see from that courtroom in there is just you, Your Honor.
Oh no. You made the decision not to cause she was giving him all sorts of room to like make decisions on this type of stuff.
Prosecution's
It's
tape.
over
I
with.
can't even see the bailiffs.
It's over with.
So there was no way for me to even see who the jury was.
That's so
Obviously, I
funny.
wouldn't know them by name. If I would have been able to see the
She
jurors, I
flipped
would have
them off.
immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now,
How
that's how I'll
hilarious would
address
that
it.
be?
I'll advise you of what her answer is later. Do you know the number of the jurors, sir? They have numbers.
I just know I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the
Bottom
top
row.
or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black
They're
shirt.
all
on.
black chairs, sir. So
The last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides, right? So it's the last chair on both sides, so I wanted to make clear. You're saying the chair closest to the television, thank you.
He said she flipped them off.
Front row.
And now he getting frustrated.
All right.
Please keep her on there.
State have copies of the.
If she did, please
filings.
keep her in the
Yes.
jury.
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding of fact.
Your request
That is
is
denied.
denied.
Even I knew that was
The
going to get
next-
denied.
Your Honor, explain why.
Mr.
it's
Brooks,
denied.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You gonna
Brooks,
explain
I'm
to
not
me
gonna
why.
have a debate with you right now. We
I'm
are
not.
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52
I still would
p.m.
like a judicial- Are you making a
says,
judicial
are you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and
Are you
courtesy.
making a judicial
They have been provided to
determination?
you multiple times. They're
Oh
part of
my
the
God.
materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not
And
disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard.
It's like he takes every opportunity where she addresses him as a chance to rebuttal. Like he refuses to let somebody else get the last
In
word.
court, will that be honored by Your Honor?
Like, he
That's
just won't
a
let
valid
it be that
question,
way.
because
Mr.
That's a
Brooks,
constitutional
I
right.
have given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right, I don't understand. But
So,
I was
but that
following-
doesn't mean we're going
Attorney?
to have a
I was
discussion
following-
or
no,
a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you set
So, the bottom
by
line is, I
writing
don't
and
feel,
sending-
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you
objections
did, and I'm going through
in
them, so
writing.
give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is,
I'm going to address the next one,
what
so
you-
please pay
what you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment?
Mm-hmm.
Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's
Brooks,
all I'm hearing.
again, you have the right to present a defense, but that right is not unfettered.
That's
That
the Sixth
right,
Amendment.
Mr.
I'm talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because
He's
you're talking
getting
about-
No,
mad.
because
you're
you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
Oh my
Mr.
God,
Brooks.
To the First Amendment, which
This is getting like. See, now we're into like deeper territory now where this dude is getting super frustrating, bro. Oh man. All right.
Clearly says that I have the right to freedom of speech.
Look at
and
the
to be
judge.
heard
Look
in
at
the
Judge
courtroom.
Jennifer.
Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial
You're
determination.
just throwing out
to not
phrases,
honor my
man.
constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
cons-
to appear
I
in this
consented-
case
I
as your own
consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have,
What is
and
that?
I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor. All I'm
Mr. Brooks,
simply-
I made
all I'm-
findings regarding that, and those findings stand, that despite you scratching out some of those words on
But-
there, I
but
made
you-
very specific findings about
That means nothing at
your
all.
waiver of right to an attorney.
That you scratched out
So we're not gonna
words.
relitigate
You
that
also,
here
you
right
also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage
We
in
did
any
not.
type of
We
that
did not
kind of
enter into
dialogue.
any
Because
contract.
that's what you're claiming through some
No,
of
I'm
these
not.
filings,
I'm
and
not
you've
claiming
said that previously.
I am not claiming that, Your Honor.
So,
In any way, shape,
Mr.
or
Brooks,
form, I do
I'm
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole
Immediate
series of
interruption.
instructions and follow the rules that you said
Right
I
away.
have to write down?
You did.
Anything that I object to and then hand it in.
Except
I
now
mean-
that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted on my
here's what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you
Can we
continue
please
to
get him to the
interrupt,
other courtroom?
you
No.
risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this.
This is-
And yes, exercise the mute button, sir.
This
But,
is-
and
this
then
is
I'll bring
something
you
that was
back when the
filed, though.
jury's back.
This was filed though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not, following the simple rule of civility that I have established.
That's
He
Get him out.
continues
Your
to
Honor.
interrupt.
Just get him out
He's
of here,
not
please.
providing
That is
this court with the
inaccurate, Your Honor.
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your honor my First Amendment right?
I'm
Or
not
are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my
You
constitution.
got
I am
you gotta
not
laugh
making
in
any
pain
such
sometimes.
determination.
'Cause,
So
like,
you
I'm
just said you're not gonna answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right
He's
to
just
present a
repeating
defense.
himself.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
Your
are, Your Honor.
rights-
You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your
I'm-
First Amendment in some
trying
respects
to
is
talk law to a
circumscribed
judge.
by the rules of evidence and the rules of procedure.
Does it say that I have
So that
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of a
I'm-
jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that you want in
Your
front
Honor,
of a
am
jury.
I
What it
being-
means, sir,
am I
is
being
that you
disrespectful?
must
Am I
follow,
calling you
yes,
out
you're
your
being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously
just get him out.
talking over me. So at this point, I'm gonna find that he's forfeited his right to be
I have
present as
not
I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any, I'm
his
You don't
simply
need to
trying
paperwork.
consent.
He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor, I
everything
do
set
not
up.
agree to a
The
estoppel.
record to reflect, I'm stepping off.
Here's another stopple. I do not agree to a stopple. Is that an actual word? It ain't one I know of.
The record should reflect that Mr. Brooks is now appearing from the other courtroom. Prior to the court taking the short break, the court was attempting to address the filings from Mr. Brooks that he made pursuant to my request, to write down if he had an objection. I have 5 different, what I will refer to as filings, one of which he provided to Deputy Wittig at 12:05, so that was right around the time we broke for lunch. A second one, 1:52 p.m., today's date, October 6th. And then there's another 1:58 p.m., October 6th, 2:03 p.m., October 6th, and then looks like the time is 14:28, so 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the filings. I need you to not interrupt me at the moment. You are unmuted. But after the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to it many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because
Here he goes again.
Frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple, it is disruptive. It disrupts my thought process, it disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections. You wrote them all down. You followed that procedure. I told you I would take those.
It's crazy. I never realized how many of these he actually did until like actually watching the whole thing.
But then you started in with your antics.
It's sad,
with your
man.
Interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice.
Because he knows what he's doing, especially at this point with so many warnings. Like he knows what's going on. It
doesn't matter to me that you're not raising your voice, you're not making any threats or any.
Like even this little shaking thing he's doing like that, like it's like a little kid would do. I got little kids in my family that do the same thing.
Level, in my opinion, but But it's
When you're
not
sitting there, you tell them,
necessary
hey,
for
stop,
this court
you
to
know,
make a
doing this and that. They
finding
just sitting
that
there
your
upset,
behavior
shaking their
is,
leg like, okay, hurry up and
disruptive.
finish.
And this obviously comes
Crazy
on the
to see a
heels
grown
of your
man act like
conduct
that.
this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent in the concept of courts and judicial proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court.
I'm glad she's putting all this stuff on the
Therefore,
record
he
too.
has
She's
forfeited
being
his
very
right,
thorough about this.
to be present while we discuss all of these filings. I'll also make a finding that
It's a little
the
objection
technology
sign.
that we are utilizing here today, we are Polycom to Polycom. The audio and video have been working very well this afternoon.
That is the funniest
No
thing.
issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate
Trying to prop it up
while
on a
the
computer
court
screen.
is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say, but what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do.
He's just
that,
holding up
within
this
the
objection sign,
courtroom.
but it's like,
So,
okay, didn't she just say like once you make an objection, it'll be noted, and then like they'll move on from there, or he can just write it down on a piece of paper, hand it to the bailiff, say I object to this. What she just like, it's just a disruption
first
tactic.
one that I will deal
Once
with is
again.
the one that's got today's date and 12:05.
But it's
addressed
funny
it
to see the
earlier,
ones that just absolutely
in
will
terms
not
of,
work. Like he's trying everything.
that I did not believe
Anything
it was
he
a
can do.
filing that required any court
That's what makes it
response.
silly at this
And
point.
I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a Seventh Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of
I want to see
paper
if he ever says at
references
any
the
point what
notice of
name he
special
consents to
appearance,
being
the
called to.
statement of
Because
particulars, both are by
I notice he
affidavit.
keeps saying he don't
Those
consent
are
to being
two
called
of
this or
the
that. But
common
what do you
sovereign
like being called then? Like,
tactics. And I believe Beneby,
It don't
the
even
language
make
that you
sense.
cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising
know he
an
don't like that.
objection, and
He
I'll
can't
indicate
respond.
for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is, they can be fettered.
I love how the judge and the prosecution are pretty much like on board with each other, because he's just, he ain't even helping himself. I'm not saying like they working together. I'm just saying like he's making it very easy for them to just be on the same page by doing everything he's doing.
Opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial. In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make
Right, he's just saying stuff to say it.
claims that have no underpinning in law or fact. It's really conclusory. This court is under no obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true in a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights.
She's being extremely fair to him too. It's weird to see him try to
with the law. And that
really
law
make this seem
is
as if
what
she's
I've
not
already,
doing anything for him. Like she's
pointed out.
explaining it and breaking
So
it down
I'm
as
going-
best she can. She can't go into like
not sure really how to address. Are you making a judicial
major
determination?
detail about
Everything
stuff,
that I
'cause then
do
that's
when
just
I rule
helping
on
him,
something is a decision that is made
which
by
isn't
this
fair
court.
to the prosecutor.
So
Then
I
that's not
answered
fair.
This. We'll move on to the next
Her
one.
coaching him isn't fair, but he
That
thinks
is
that
the-
is for
and
some
he
reason.
is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely upon the Beneby decision from the Seventh Circuit, that these are just
Delay
various
tactics.
arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed. This court will refer to the name that is on the information in this case. That is the official charging document, and that is what I will do. If I mispronounce his first name at times, my apologies. I know I said his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right. Or words to that effect. I mean, I have the exact quote, and I'm not quoting him.
So that's not your name, though,
but
but you
confirmed
confirmed.
at that point what his first name was.
That's funny.
His continuing
Yo.
objection about his name is so noted. It's preserved in
He
the record
actually
based upon
confirmed
his
it.
filings, and I'm not going to address it further. Frankly, his last document, which says a plea is to argue facts. I don't intend to do that, and I never agreed to or consented to a, quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the plea questionnaire waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified by Mr. Brooks, and that juror confirmed she has not attended any proceedings. So that issue is addressed now. He's holding up his objection sign, Mr. Brooks.
And a lot of these are questions that could have been answered by an attorney if he had
It
one.
really is an important issue, and I appreciate that. I was a little surprised by it, but then when I heard you explain further, I thought, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that, and so that's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your
The juror that flipped them off.
issue with her. All right, now the next step would be opening statements. So, Mr. Brooks, you have demonstrated in the past, and I'm going to unmute you, that when the jury is present, you are able to maintain civility, show them respect, show the courts and the process respect and dignity. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
Today,
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you, I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules when the jury is present. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
that's
Mr.
exactly
Brooks,
right.
it's your conduct in this courtroom is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
do
that.
then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is
This consent
about the
thing
decorum and all this.
is killing me.
That's what you say. But when I'm raising issues of understanding, which I keep
This is
telling you
my
I
first
don't
time hearing
understand,
sovereign
then it's
citizens
looked
like,
at as being disruptive.
I didn't know
It's
they
looked at as
thought this way. Like,
intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking
Attorney.
questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings,
I
but
am not obligated to answer questions.
You made
when
those
you ask
filings.
me questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law.
there you go.
I am obligated.
Now he
to
throwing
address,
stuff. What a little kid, bro. Now he mad at
motions
throwing
to
stuff. He
address
got muted.
that are based in law and fact. I'm obligated to,
Yo, it's
to
so
address
funny, bro.
objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I am not obligated, sir, to provide you with an explanation of the law, of the procedure. And
That's
with
exactly
that,
right.
since I gave him 2 opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and
There you go.
civility, and without
That's-
such a pledge, he will remain in that courtroom.
I'm glad she
He's
stayed
muted.
solid on
The
that.
record should
Yep.
reflect, it appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right, then we will have the jurors
You all right?
brought in, and then the state can then proceed with its opening statement.
I'm sorry. You don't do nothing yourselves. All right. Okay, let's get back to it. 3, 2, 1. Hold on. Let me go back. 3, 2, 1.
Mask, and I just wanted to make a record of that.
What's going on, everybody? I know I said I promised in the community post that it was going to be a 4+ hour reaction. A lot of work came up on my desk, so unfortunately I have to take care of that, and then I will put up a part 2 where we will finish out the remainder of day 1 of this trial. Nonetheless, I hope you guys did something good for somebody today. Hope somebody did something good for you, and I will catch you guys in the next one. Peace.